Good evening, my dear friends and colleagues. Today we have an important discussion on the subject matter of Writ of Mandamus. Nowadays, only two types of writ petitions are filed. Most popularly as writ of certiorari, Writ of Mandamus, or a certiorari refined mandamus. We all know what certiorari means. It means the power of judicial review of the High Court under Article 226 on the decision or the decision making process or finality of the decision making process. And we all know what a mandamus is. A mandamus is a writ which can be issued by the High Court under Article 226 by establishing that the aggrieved person are entitled to enforce his statutory, legal or any other right which is denied by the authorities, a public authority or an authority who is having a force of law. In simplicity, a mandamus can be levied or issued by the High Court only in case the petitioner is having a civil right or a legally enforceable right. As we all aware that every right cannot be exercised or cannot be compelled by invoking a writ of mandamus. The rights in general with a broad base can be identified as a civil right, constitutional right, fundamental right, a right under the statutes, or a right of equality or right of by way of claiming it as natural justice. So these are the broad-based rights. If at all, if it is a civil right against another private individual, if the private individual is not having any public authority or public duty, then we have to go to the civil court. Generally, we are filing mandamus of several nature. We can have certain examples to find out what are all the rights which are claiming by us in mandamus writ petitions. Basically, the present litigations and the litigation area is that writ of mandamus is filed for considering the representation of a citizen, or where an appeal is preferred and no orders have been passed, or where there is a claim for a license or a contract or issuance of any certificate or any statutory process which are expected to be fulfilled by the public law enforcing authorities. First, let me look at it in the perspective of mandamus to consider representation. Mostly, this writ petition may be very common to all, that when a representation is made by a citizen having a right and it is pending with the law enforcing authority for a long time, his right of speedy disposal or an earlier consideration is deprived of. It may be looking right to claim for a right of consideration of representation or a right of consideration of the grievances from the law enforcing authority. The right of consideration have a precondition that you must have, or the petitioner must have, a vested statutory or legally enforceable right. The representation simply by making a claim which is not having a statutory base or a statutory right or any other right which is protected by any enactment, simply sending a representation and seeking the court to consider the representation will be certainly an abuse of process of law and misusing the powers of the High Court under 226. Nowadays, several types of writ petitions are filed with the representations. In considering the pleadings or the affidavit, there is no averment to that effect. The representation is made for the enforcement of any right, and the denial of the public law enforcing authority. So the writ petitioner is coming to the High Court for enforcing the statutory right of consideration. Two important aspects as well as important pleadings must be available for maintaining and have a successful finality in the writ petition, mostly in the case of mandamus. Number one, that the writ petitioner is having a legally enforceable right. What is legally enforceable right? The right which are protected by statutes, right which are protected by the principles of natural justice, the rights which are protected under the Constitution, the right of getting an order without an arbitrariness or a discrimination, or a right under Article 21 or 19. All the fundamental rights are codified under several statutes. When a representation is made to the public authority, the representation may not be clear about the statutory right or right which is deprived of to the individual. At the same time, when a writ petition is filed, it is a duty of the counsel to prepare an affidavit very definite with a definite pleadings that the representation is made for the purpose of claiming or protecting a legally enforceable right. Unless the affidavit discloses that the petitioner is having a legally enforceable right and there is a equivalent, a duty or responsibility of the law enforcing authority to perform the duty as per the statutes, there cannot be any writ of mandamus to consider the representation. Recently I have come across a case where a panchayat president filed a writ petition claiming that the contract of the government should be given only through the panchayat, village panchayat. The first question raised by us is that what is the statutory right of the panchayat president? The panchayat president sent a representation and filed a writ petition claiming that their statutory rights are affected, seeking for a mandamus, etc., etc. The next question is whether the respondent public law enforcing authority are having any duty or responsibility either to do or not to do certain duties in case of a denial of a duty or in case of denial of a duty which is cast upon them, which is depriving the right of the statutory right, a mandamus can lie. In that particular case, the point decided was a panchayat president has no right either under the Panchayat Act or under the government orders or under the regulations and rules, wherein a panchayat president is entitled for a contract under the statutes where the state funds are used under the schemes. So the case was negative in a preliminary stage for not establishing a statutory right which is vested with the petitioner. Simply by sending a representation and filing it as a writ petition without disclosing or pleading that there is a statutorily enforceable right which is available for the petitioner and there is a denial of the statutory obligation or duty of the public law enforcing authority, the writ of mandamus is not maintainable. Most of the writ petitions are filed with the prayer of considering the representation. It is not proper to comment on those type of filing of writ petition. At the same time, we have to be doubly cautious that are we doing justice to the client Are we doing justice to the litigant who are coming to us to get some justice through the court under Article 226? So before filing a writ of mandamus for considering the representation, you are creating a cause of action. Simply if it is directed to be disposed of without deciding what the legal right available with the petitioner, what is the denial of the duty cast upon the public authority, there will be a finality in the proceedings that the authority will say that you don't have any right and it will be rejected. So to avoid multiplicity of litigations and to avoid unnecessary litigations, I request my friends, while filing a mandamus, please make sure in your affidavit to establish by specific terms in your affidavit that you are having a legally protected right and the respondent public authority are not performing their duty to implement or to enforce that particular right which you are legally entitled to. Without that pleadings, there cannot be any representation. When the representation is without any right, there cannot be a direction to consider the representation which is not proper. And even in case of any finality is given in the petition, without deciding legally enforceable right, it will be a wasteful exercise. It may not be proper for the advocates to simply filing an affidavit with a few paragraph of reproduction of the sum and substance of the representation and seeking for a direction to dispose of representation. So my personal view and my suggestion to my friends is that when you make a representation, you please make sure that the representation is for the purpose of enforcing a statutory right or a vested right which is protected under the Act or rules or under the principles of natural justice. Otherwise, even if it is disposed of, we can't do justice to the petitioner coming to the court. So you please make sure while drafting the affidavit that the representation is to protect your statutory right. Then for this purpose, you can have a small 2 paragraphs of the settled law by the Supreme Court in 1977, 1 SCC 486, para 9. I will repeat, 1977, 1 SCC, para page 486, in Mani Subrat Jain versus State of Haryana, where the Supreme Court, 3 judges benches of the Supreme Court very specifically said that unless there is a legally enforceable right protected and the public authorities are not performing their duty to protect that right, the mandamus may not be laid. And there are other judgments also to that effect. In 1962, Supreme Court 1210, Dr. Sai Shivendra Bahadur versus governing body, in para 5 it is also once again reiterated that for maintaining a writ petition, as I said earlier, there must be a specific pleading that the writ petitioner is having a vested legal right and the duty of the public law enforcing authority to protect that right, either by doing something or by not doing something. Only then a writ of mandamus will lie. So we will come back to the second subject, issuance of several positive directions we are claiming through mandamus, like seeking for patta, seeking for license, seeking for contract, seeking for promotion, seeking for seniority, seeking for retirement benefits, seeking for any right which you are legally entitled to. So the question is, in these type of matters, we have to go to the relevant provisions of law. The relevant provisions of law, by tracing the right under any of the statutes, you can come across the provisions or the rules will give some right to the litigant to be enforced and certain duties vested with the public law enforcing authorities have to be fulfilled. Before filing a writ of mandamus, you please make sure that your pleadings and your client are having a right under the statutes and it is deprived. With this I conclude this discussion that, my dear friends, before filing a writ of mandamus for anyone of legally enforceable right, make sure that your pleadings are complete and your pleadings are very clear in your claim and very clear in your rights, which is deprived by non-consideration or by deprival of inaction or overaction by the lawfully enforcing authorities. With this I conclude that writ of mandamus need not be filed on trivial issues unless there is a legally enforceable right in favor of the petitioner. Thank you.